Thank you, comma, Your Honor, period. The motion to dismiss is predicated essentially on two different things, period. Initially, comma, it is our contention that, comma, particularly now, comma, based upon the testimony of Ralph May, comma, the person who signed the affidavit, comma, that the court is without jurisdiction at the present time over the offense, comma, and the court was without jurisdiction to allow the filing of the direct information because Ralph May, comma, who signed the affidavit, comma, did not have direct personal knowledge that the offense was, I'm not sure what I was going to write here. Comma, and that the facts stated in the information were true, period. The second thrust of the motion, comma, Your Honor, comma, is the constitutional issue that, comma, under the facts of the case, comma, the filing of the direct information without any judicial determination of probable cause, comma, and without any inquiry by the court into the evidence, comma, shall be basis for the case itself, period. When the defendant does not have a preliminary hearing, comma, and did not waive the preliminary hearing, comma, violates the defendant's rights to due process of law as guaranteed by federal and state constitutions. Comma, and further violates his right to equal protection of the law, comma, and equal justice as guaranteed by the federal and state constitutions, period. It further violates his constitutional right to demand the nature and cause of the accusations against him, comma, and to meet it. These essentially are our grounds on this motion to dismiss, period. I'm not sure, comma, but I would just like to highlight our position in the matter for the record, comma, and to be certain that the court understands my position on this case, period. I have filed a memorandum in support of this motion, period. The problem is, comma, at this point, comma, one of the jurisdiction should be jurisdictional problem, comma, and the constitutional problem, period. Jurisdictionally, comma, Your Honor, comma, our position is very simple, period, semicolon. Colon. We claim that when the information was filed in this case, comma, and the court can take judicial notice of its own records in this case, comma, there was no inquiry by the court or the district attorney concerning whether Mr. Dale had a preliminary hearing, comma, or whether he waived a preliminary hearing, comma, or whether, comma, in fact, comma, the person who signed the affidavit, comma, Ralph May, comma, was in fact an eyewitness to this incident, comma, or whether he had some personal knowledge of the incident as I alleged in the affidavit, period. Now it is our position, comma, Your Honor, comma, that generally a defendant under our statutes is entitled to a preliminary hearing, period. The revised statutes in effect, comma, currently, comma, virtually makes it mandatory that a preliminary hearing be held in a felony case, period.